Hello, my name is Josh Blackman, and welcome to the 2022 Harlan Institute Ashbrook Virtual Supreme Court competition. This year, we're mooting the case of students with fair admission versus the University of North Carolina. We are now in the semifinal round. This is match number 7. For petitioners, we have Vikram Valame from the Gunn High School in California. And for the respondents, we have Lauren Holt and Han Lee from Creekview High School in Texas. Ready to begin? Petitioner, whenever you're ready.
Thank you, Your Honor, and may it please the court. Students for Fair Admissions is filing this lawsuit against respondent University of North Carolina to strike down its policy of assigning racial admissions benefits to Black, Native American, and Hispanic students on the grounds they violate the Equal Protection Clause of the United States Constitution. Although this court has previously held that an interest in racial diversity can sustain racial discrimination in higher admissions, those decisions, Grutter and Bach, both fail the stare decisis test and should therefore be overruled. Starting on the question of the stare decisis framework, this court has identified several factors important to the inquiry. First and foremost is the status of the decision on the merits. In this case, Grutter is plainly erroneous because it flouted the strict scrutiny test for compelling interest, does not apply proper means and scrutiny, and is not consistent with the original meaning of the 14th Amendment. Secondly, are reliance interests. However, this court has been non-receptive to reliance interests in the cases of racial discrimination, and especially in cases of discrimination involving education. If there are any concrete reliance interests at stake here, race-neutral alternatives can quickly obviate their need. Finally is the question of workability, whether a precedent can be rationally and reasonably applied in a wide set of cases. However, Grutter has proven unworkable both in this court and the lower courts, with applications that both stretch its logic and undermine its central holding. Because Grutter satisfies each of these stare decisis factors, petitioners urge it to be overruled.
Thank you, Counselor. Let's start off with history. Could you please talk a bit about some of the legislation that was enacted by Congress in the 1860s and how those statutes might affect this case?
Certainly, Your Honor. Brief preface, no. Although the 14th Amendment only mentions the states by name, this court has held that congressional enactments do fall within its purview due to the Due Process Clause. However, when undertaking an originalist analysis, one should not fall prey to halfway originalism. At the time of the 14th Amendment ratification, the federal government was not believed to be covered by it, and therefore federal laws have very limited insight. Now,
Go ahead, answer the question. Yeah, go ahead.
To answer your question directly, there are a few major laws that were passed during the time. First is the Freedmen's Bureau. This law is entirely consistent with our position. It served a narrowly tailored, compelling remedial purpose after the bloodshed of the Civil War and 40 years of race-based slavery. Indeed, this court has held that the government may indeed have an affirmative obligation to remedy past wrongs committed by the government. I believe that was Adirondack Constructors via PINA and part of the holding of Metro Broadcasting. So insofar as the Freedmen's Bureau exists, it plainly fits under a remedial purpose. Now, respondents also point to an executive order that was issued by the president during 1861 that prohibited federal discrimination in hiring. However, that order on its face makes no distinction between races. It merely prohibits the use of race or national origin in any hiring decision.
Right, but Counselor, let me just maybe push back a little bit. I mean, I agree. Some of the statutes were written without regard to race, but there were some statutes that did mention color, right? The statutes did mention that. Wouldn't those sorts of laws suggest the framers were comfortable with race-conscious benefits provided by the government?
Well, Your Honor, our position is not that race can never be the source of government benefits, only that it must serve a narrowly tailored, compelling state interest. That interest in the immediate post-Civil War area was the remedial interest. And as this court has said in cases like Richmond, when the government identifies with specificity people who have been discriminated against and has strong evidence to conclude that remedial measures would make them whole, it can enact race-based laws. And in the immediate post-Civil War period, it is not difficult to see how most such laws clearly met the test, because Blacks have been enslaved for 40 years in the South, been subject to massive racial discrimination, even when free, and were otherwise disadvantaged in ways directly perpetuated by the government.
Counselor, here the identified state interest, the compelling state interest would be diversity. So how does affirmative action not meet that state interest?
Affirmative action does not meet that state interest, and it is petitioner's position that that is not a compelling state interest. I'll take each in turn. First of all, UNC admits that it has no way of actually measuring how close it is to achieving the, quote, critical mass that Grutter said was the compelling interest in this case. It admits on Joint Appendix 401 to 402 that it does not even discuss the existence of a critical mass when making admissions decisions. Therefore, there is simply no evidence in this record that affirmative action is actually seeking to is actually creating the benefits that this court described as a compelling state interest. However, secondly, racial diversity, however framed, cannot be a compelling interest. This court announced as much in Grutter, where it said that at most the compelling interest could be exposure to a wide range of ideas, including viewpoints, peoples, nationalities, geographical locations, etc. However, the system that the court legitimized, where administrators get deference to their administrative decisions, only focuses on race and does not include these other factors in.
So, Counselor, if I could jump in there. So you're saying that, if I understand your answer to Justice Hicks correctly, diversity is never a compelling interest to justify racial classification. Is that your position?
Yes, Your Honor. Diversity is never a compelling interest to achieve classification. And I'll make a caveat. Unless there's some direct other interest that is compelling, that diversity is somehow critical to
such as remediation, which I think we said before.
Yes, Your Honor, remediation. It's possible that there are other interests.
So, I mean, North Carolina has a sorry history with race, Jim Crow and otherwise. Wouldn't perhaps you say North Carolina does have an interest in remediation?
Your Honor, this court has previously rejected the broad race-based racial relations justification for remedial measures in the redistricting cases. I want to say Shaw v. Hunt. Shaw v. Hunt was a redistricting case, and essentially in that case, the court said that although a state may have a checkered disparate past, that there is no debtor race, there is no creditor race.
Okay, so let's take Michigan. So let's take Michigan. That was not a slaveholding state. That was not a state that enacted Jim Crow laws. Would Michigan ever have any justification to use race in their university admissions?
Yes, Your Honor, Michigan would. If a student came to Michigan and said, I have been unlawfully discriminated against by a state or local government, or
let's say that there's no history of such discrimination. Let's say no one makes that. And I'm saying straight up that there's never a basis of solely on diversity. That's never going to be a basis by itself that works.
No, diversity alone cannot sustain.
Okay, got it. Okay, thank you. So let me ask you a follow-up question, please. Let's say that we rule in your favor. We overrule Grutter, we overrule Bakke, we overrule all these cases. And in a couple of years, the universities come to us and say, our classes are basically all white and Asian kids, right? We are not able to achieve any sort of diversity. We can't have any African-American students because we're just not accepting them. We're not able to, given given what the court did here. We tried socioeconomic, it didn't work. We tried everything. Would you be willing to reconsider your position that maybe there's some use of racial preferences to avoid having classes that all look alike?
No, Your Honor, but if you'll permit me, I would like to fight your hypothetical a little.
You can try. Okay, but I might push back. Go ahead.
The evidence presented in this case and a host of other states across the nation shows that it's simply not going to happen. Take California, for example. When California enacted a proposition in 1996 banning the use of race in admissions, racial race did not collapse, and the University of
California, I believe California filed an amicus brief here saying that they cannot achieve the numbers they want, right? The university is saying with Prop 209, the proposition you mentioned, we can't achieve what we want, right? So shouldn't we listen to what happened in other states and try to avoid this experiment happening nationwide?
Your Honor, 2 points. First of all, California cannot make that claim when Grutter has specifically said there is no number that a state can say we won, and that is a compelling state interest. Indeed, that is patently unconstitutional. Secondly, in this case specifically, we have evidence that a socioeconomic factor would work. If you look at Joint Appendix 574 and 576, we've shown that a plan that would dedicate 750 seats to socioeconomically disadvantaged students would not meaningfully reduce diversity or test and GPA scores. For the foregoing reasons, I urge this court to reverse and overrule Grutter v. Bollinger. Thank you.
Okay, thank you so much, Counselor. You fought my hypothetical well enough. All right, if the respondents can please come on the screen, please, and you'll have your 15 minutes and begin whenever you are ready.
May it please the court. My name is Lauren Holt, along with my co-counsel Harlan, represent the respondent, the University of North Carolina, in today's case.
The question before the court is, should this court overrule Grutter v. Bollinger and hold that institutions of higher education cannot use race as a factor in admissions?
This court should rule that to not overturn Grutter v. Bollinger and that places of higher education can use race in their admissions process for the following 3 reasons. 1, affirmative action is consistent with the 14th Amendment. 2, affirmative action meets strict scrutiny's requirement of a compelling interest. And 3, affirmative action meets strict scrutiny's requirement of being narrowly tailored.
Starting off, affirmative action is consistent with the 14th Amendment's intention. The intention of passing the 14th Amendment was to ensure equal rights to all citizens by redefining what it really meant to be a citizen by including formerly enslaved persons within that definition. It is provided by the Equal Protection Clause that no state shall enforce any law or which shall abridge the privileges or immunities of the citizens of the United States. Furthermore, the Civil Rights Act of 1964 prohibits workplace discrimination on the basis of color, race, and national origin. Although the Civil Rights Act was to end workplace segregation, it is comparable to affirmative action because its purpose both was to serve to educate people about the different ways others lead their lives. The 14th Amendment is in nature about race. It was written right after the abolishment of slavery, along with other documents that discuss voting rights for voting for not on the basis of race. It may be stated as the privileges of the citizens of the United States. However, prior to this, the involuntary servitude workers were not considered citizens or even part of the population.
Counselor, if I could interrupt you, are you talking about which provision of the Constitution is relevant here? Is it the Privileges or Immunities Clause or the Equal Protection Clause? I think I heard you mention a couple different parts of the Constitution.
Your Honor, I am mentioning the Equal Protection Clause within the 14th Amendment that ensures equal rights to all people, and it was stated as to all citizens of the United States, and in the Equal Protection Clause, it was redefining what it meant to be a citizen, because prior to this, involuntary servitude workers were not considered citizens.
Very good. All right, so let me ask you a question, please. How do you understand Justice Harlan's dissent in Plessy v. Ferguson?
Your Honor, Justice Harlan's dissent in Plessy v. Ferguson was
that the well, Your Honor, it was that the Constitution was colorblind, but seeing as the Constitution does mention the 14th Amendment, which is on the basis or revolves all around race, the Constitution is not colorblind in the sense of race. Although it does, its Constitution, the race, there should not be discrimination or harmful discrimination that is not constitutional. It is not colorblind in the sense that race is not mentioned.
Do you think that Justice Harlan was wrong to say it was a colorblind Constitution?
Well, Your Honor, we do think that Justice Harlan was wrong in his dissent because the Constitution is clearly not colorblind as it mentions race itself.
Where does it mention race? Maybe you can help me out there.
In the 14th Amendment, it says that nor shall any man be discriminated on the basis of race.
I don't think it says that.
14th.
It says that no state shall deny anyone the equal protection of the laws.
Oh, yes, Your Honor.
Additionally, in the 15th Amendment, it mentions that no person should be taking the privilege of a right to vote on the basis of race.
That is correct. The 15th Amendment does mention race, but what it says is the government cannot discriminate on the basis of race, which would mean no matter what color you are, you're treated the same, which is why Harlan would say it's colorblind. In other words, where do you get the idea that you can treat people differently based on their race? Where does that come from in the Constitution?
Well, Your Honor, it is not the basis of treating people differently, but simply affirmative action is a factor of using race as a factor among many.
Okay, good. Well, let's talk about that. When will, oh yes, this question. Your friend on the other side said that you never define what you're looking for in diversity, right? That this may never actually be achieved. How will you know, counselor, when you've had enough diversity, when you've achieved the requisite level of diversity and you don't need to use racial preferences anymore?
Well, Your Honor, this is taken on a case-by-case basis, and universities can view, for example, their student population. As UNC states, a main purpose for the diversity.
I get that. I get how you
that-
race. No, I'm sorry to interrupt. I get how you use race on a case-by-case basis. My question is different. When will you no longer need to use race? Will that ever happen?
Well, Your Honor, it is surely to happen, but it's simply unfair that we have not met the point that race is no longer needed. And universities can decide whether they need it or not by surveying their minority or a minority population on campus. As the main factor, one of the main factors UNC states is that minorities feel represented and connected on their campus, Your Honor.
Not all minorities, though. I mean, in this case, at least, there's some minorities, Asian Americans, who do not feel represented and they feel excluded. Could you address that, please?
Well, Your Honor, on the basis of Asian Americans are similar to all other races in the sense that it is used in a holistic process. As Bakke ruled a quota system unconstitutional, and thus Grutter uses a critical mass that is not determined of a number, but instead an amount that makes students feel represented on their campus. And thus, Asian Americans are simply viewed as all other races as a holistic process, taking in all factors that would go into their race, not race being a determining factor or a major factor, simply a factor among many.
Furthermore, if we look at race as a holistic factor and we view it as discrimination, then all the other factors that take into the admission of a college applicant, such as grades, would be viewed as discrimination, and therefore every rejection could be argued to be discrimination.
Yes, Counselor, I'm going to push back a little bit on that because things like grades aren't a constitutional guarantee or are protected by the Constitution as much as something like race. So if I can pose a hypothetical to you, if I have two students that both are identical in every way, and one is an Asian applicant and one is a Black applicant, is race going to affect their admission to your university?
Well, Your Honor, it is simply, well, Your Honor, yes, Your Honor, in a way, because it is a factor that is taken into account, but it is simply improbable to say that any person, as every person is unique, will come to the same circumstance where everyone will be of the exact same statutes, as most people develop in different club activities. And also there's a point of personal essays that are written uniquely per person. And thus, while race is a factor and could potentially be a deciding factor, it is not potential to compare it to one person being exactly the same as another, Your Honor.
But if we have all these points in the application, why exactly do we need to know the applicant's race?
Well, Your Honor, racial diversity is a necessity among campuses. As Grutter states, many schools, such as Michigan Law School and Grutter-Villinger, are very stepping stones for politicians in our country. And UNC even has a separate law school connected to the campus, which is important as we can see that the majority or 1/4 of the House of Representatives, for example, has come from a law background, and seeing that there is a 14% disparity between the elected minorities in the House and the population in the U.S. that there is.
So, Counsel, if I can interrupt you for a second, I hear what you're saying about certain minorities, but again, the other side makes the argument that Asian Americans, which are underrepresented in society, are put at a disadvantage, that their scores are they need higher scores to get in than, for example, African-American applicants. If your interest is in diversity, why aren't you treating all racial minorities the same?
Your Honor, the Asians who are rejected are the lower margin of achieving, and they're about the same as the highest achieving Hispanics and other minorities.
Oh, well, I'll ask you for the other side about those numbers. Let's talk about stare decisis. How do you understand stare decisis? Why should we stand by Grutter and Bakke?
Your Honor, in stare decisis, like there have been cases like Dobbs traction that overturned another case. However, it was overturned because the issue was not explicitly mentioned in the Constitution. However, in today's case, we're discussing affirmative action, which is related to race, which is in the Constitution.
But your counselor, affirmative action and the use of race to excel some races over another in the scholastic setting is not specifically stated in the Constitution, correct?
Yes, Your Honor.
And continuing, Your Honor, opposing counsel states that Greta v. Bollinger in the use of race is not constitutional unless remedial. Although in consideration to the disparities between population of minorities and populations in Congress, and that law campuses are the necessary stepping stones for those people that get there, as 1/4 of the House of Representatives, as example, is the law background, then it is of a remedial context. And while the opposing counsel does
I'm sorry. So I mean,
unless
I'm sorry to interrupt. So I'm sorry to interrupt you, Counselor. Are you saying that UNC is engaging in remediation, or is this about achieving the educational benefits from diversity? Just so I make sure I get your point.
Well, Your Honor, while the benefits of education of diversity on campus is apparent, universities are not just about what goes on campuses, but what happens afterwards. So the benefits of diversity in education is apparent on campuses as helping lessen stereotypes and other benefits, but also we must take into account the effect of after graduating from those campuses. For example, another example is the military. The military in Grutter is apparent as they say that they need both to ensure national security, they need an officer corps that is both racially diverse and highly educated. While opposing counsel does reference in his brief that maybe recruitment in military is sufficient to sustain diversity in the military corps, on the other hand, the military corps states specifically highly educated.
Counselor, I have a question. So the compelling interest, which is to create diversity, one of the benefits of that is to bring about people from different backgrounds, so that there's an open discussion from people with different experiences. How is affirmative action narrowly tailored to do that without taking into consideration that just because somebody is from one race, they would have a different background from somebody with another race?
Your Honor, affirmative action is narrowly tailored as stated in Grutter that it can only be used as a plus factor and used holistically. So if race is taken into consideration as a holistic factor among many other factors, then it is narrowly tailored. And cases prior to ours, such as Bakke and Grutter, has been adjusted to meet that standard.
And additionally, on the basis of continuing on remedial context, opposing counsel also argues that it has to be specific in order to suffice remedial context for discrimination, although discrimination itself is a definition of prejudice against categorized groups of people, not specifically. And thus, to address that, to get remedial context, we must go as a race in its whole and still goes person by person. But opposing counsel's argument of specific for remedial context is inconsistent when arguing against affirmative action, Your Honor.
Well, counsel, let's talk about sort of sort of a stopping point, right? In Grutter,
Mhm.
what did the Supreme Court say about how long we would need affirmative action for? What did the Supreme Court say about that in Grutter?
Your Honor, the opposing counsel did argue that and the reliance interest in Janice did issue a 5-year
Didn't Grutter, I'm sorry, we're running a little short on time. Didn't Grutter say there was a certain number of years that we would need affirmative action anymore?
Grutter did say 25 years, although that was simply a time not, it was, my co-counsel was trying to explain, not comparable to Janice, which was a 5-year expiration date, but simply a time in which to readdress the case in which we are doing today, in order to do a case-by-case basis and a hopeful thinking in order to readdress and not a reconstructive and thus incomparable to Janice. I see we are running out of time. May we conclude, Your Honor?
Yes, you may.
If there are no further questions, then Grutter has met Shikskuni by demonstrating a compelling governmental interest that's consistent with the 14th Amendment and is narrowly tailored. Thus, it should not be overruled. Furthermore, higher institutions should be able to use affirmative action as a factor in admissions because it is handled holistically and does not harm the rights of applicants. It is for these reasons that we pray the court should uphold the ruling of the lower court and in Grutter v. Willinger and hold that institutions of higher education are permitted to practice affirmative action.
Okay, Counselor, thank you so much. All right, respondent, you now have 5 minutes to go up.
Thank you, Your Honor. The Constitution is colorblind. The Supreme Court, this court, in Brown v. Board of Education, expressly rejected many of the same categories of arguments respondents now make in defense of affirmative action. It found that the Constitution's original meaning was at best inconclusive, a conclusion that is entitled to stare decisis effect. It explicitly ratified Justice Harlan's dissent in Plessy v. Ferguson, which respondents now concede must be rejected in order to rule for their position. Because
Counselor, so I mean, I take it that you agree with Justice Thomas that the segregationists in Brown and the diversity officials in Grutter are like the same. Is that your position?
Your Honor, although Grutter is cloaked in benign interests, the fact that it declares some minority groups essentially lesser and other groups greater and therefore not deserving of protection is similar in kind to the justifications used by Southern officials to maintain racially segregated schooling. In that sense,
you can see why somebody might be offended by that argument, because on the one hand, in Jim Crow, they were trying to keep Black people subordinate. And here UNC is taking, good efforts to, bring back Black people into society. And I apologize, your timer's not on. I know it's roughly about, I'll give you say 3 minutes. I'm sorry.
I have a timer with me.
My 3 minutes about, yeah.
Yeah, 3:30.
Okay, 3:30.
Your Honor, we don't mean to denigrate the efforts that UNC is taking. We believe that they have a way that they believe is right to increase racial diversity, which they view as compelling interest. But UNC's views cannot override the views expressed in the Constitution and ratified by the people. And those amendments unambiguously prohibit government consideration of race. Indeed, where the Constitution mentions race, it is only to say that the government cannot discriminate based on race. And that is its most fundamental obligation in the area. Respondents maintain that universities have an interest in diversity that goes outside their borders. However, universities have never articulated a way to actually measure their interest. Respondents cite a variety of factors, from the percentage of minorities in the House of Representatives to the feelings of students on campus. But as a factual matter, UNC admits and admitted at trial that its admissions office does not consider these factors when making decisions about admission. Therefore,
Counsel, I mean, let me ask you a question though. If we rule in your favor, it's going to inject the courts into a lot of admissions decisions, because virtually anyone who's denied admission can claim it was a violation of this opinion. If we write, so let's say we rule in your favor, right? We rule in your favor. What sort of deference should we leave? What sort of room should we give the universities to try to comply with this in good faith? Or should we just make it a ruling that almost everything the schools will do will be illegal? I mean, how should we write an opinion if we rule in your favor?
I think this court should, well, the petitioner's position is that this court should use the well-established test in Arlington Heights. As long as a policy is facially neutral, a putative plaintiff has to prove that it was, one, racially motivated and would not have been enacted without that racial motivation, and two, that it has a disparate impact on a race and that they are harmed by that under Article 3. That is the same standard applicable to all governmental action. And this court has repeatedly rejected assertions in those cases that it would lead to a flood of lawsuits. Although it will expose universities to some lawsuits, that is the price we pay for complying with the Constitution of the United States.
Well, but then how do we deal with reliance interest though? Because universities have been doing this for half a century, and we're going to be suddenly saying, okay, you have to stop, right? You cannot do what we did yesterday. And you know, hasn't our sort of society come to rely upon affirmative action? And I'll just ask one more question. I know you're short in time. This isn't just about higher ed. It also affects government contracting. It'll probably affect military recruitment. It'll affect all facets of government. How do we sort of stop an apple cart that's been going for half a century in such short notice?
3 responses. 1, Grutter expressly held that it had a 25-year deadline on its holding, which was concurred with by 7 justices in that opinion. That deadline, which expires in just 5 years, should obviate most reliance interests. Secondly, with regard to other cases, the government contracting of the kind that was upheld in Metro Broadcasting was justified based on the unique expertise of Congress and the strong basis in evidence the FCC provided about the need for broadcast diversity. This holding will not necessarily take down those other uses of race. Finally, again, Congress, this court has held, might be entitled to some special deference not owed to the states. I see that my time has expired. I strongly urge this court to reverse the decision below. Thank you.
Thank you so much, Counselor. And the case is submitted. Wow. Congratulations. All right. If the other team can please come back on back camera. That was really impressive. I think that's one of our best rounds yet. It's also first thing in the morning. I'm feeling fresh, but that was very impressive. And I think both teams distinguished themselves. By the way, Vikram is what, 7 in the morning there about?
Yeah.
Yeah. So he's in California. So he's super duper early. I guess it's now up to 8. But he started off at 7:30 in the morning. So I do appreciate, was it before your classes started? That was my guess.
Yeah, I'm gonna head to school in a few minutes.
When do you start class?
9.
Oh wow, yeah, class soon. Okay, good. So I won't keep you too long. I figured you put all the early slots. That's I figured how you were scheduling it. But that was extremely impressive. Both teams, you were poised. You didn't panic when I came at you very hard. You held your cool. And even if you weren't sure, you were honest and you said, no, I'm not really sure, or you sort of moved on to a strength. And what we really liked is you all pivoted, right? If you didn't know something, you were able to go from one strength to another. So that was very impressive. I have to remind myself that you're a bunch of high school, you're 15, 16 years old. You're a bunch of high school students and you're competing at the level that, I see with my law students every day. So that was really impressive. And I'm hoping Abby and Daniel, who are my students, can maybe give you also some feedback to just comment on how you performed.
Yeah, I don't have next to any criticism. I think that's the strongest round I've witnessed. Great job on both sides. Y'all did a really good job of responding to the judges' questions. And those are hard questions. I don't know half the answers to some of those questions, but y'all managed to take it in stride. And if you didn't quite know the exact thing that you wanted to say, you quickly pivoted to a field that you had more knowledge in. So great job. Y'all did a better job arguing than a lot of law students I've seen. So good job.
I agree.
Yeah, just to piggyback off of that, you guys did wonderfully. You guys answered the questions directly, fed off of one another, the team. You guys fed off of one another. There was never a question, as to who was going to answer the question. If one of your teammates was kind of flailing, the other one picked it up quickly. All of you guys just did so amazing. I agree. This was the strongest round I've seen, and go to law school and take part in moot court.
Are you all interested in law school? Vikram, you?
I'm interested in law school, yes.
And then Lauren and Han, you interested in law school, maybe?
Yeah, we have a couple years, but yeah.
Are you sophomores?
We're freshmen.
Freshmen. What are you, 13, 14 years old? Oh my goodness. Well, I'll tell you, I've had a lot of people who started this as freshmen and they do it all 4 years. And from your school, Creekview, I've had people who started as freshmen, and by the time they make it to their senior year, they're in their championship round. So I hope to see you for 4 years to come. I mean that sincerely. Let me just give some more just some more feedback. You can first off, it's hard to do this by yourself because you kind of have no one to turn to, but I thought that was very impressive. I appreciated that when you were up there, you were taking very detailed notes when the other team was speaking. I saw you writing stuff down and you were sort of taking notes. That you didn't have to keep your camera on, but you did. So anyway, but I saw that you were taking notes. Also having at your disposal record citations, the joint appendix is impressive. Abby's nodding her head, Dan's on it. Most law students can't do that, right? So that's good. Also, you had a lot of cases. So just a few, this is so familiar, but it's Adirondack versus Pena, not Pina. Just completely, I don't want to tell you that, but I just, because if you're saying case name, you just want to say it right. But it's Adirondack versus Pena. But yeah, you had Arlington Heights, you had a City of Richmond versus Croissant with remediations, you had all the right cases. So for Lauren and Han, also, what I liked is that you didn't blink at my questions. I was pushing you really hard about Justice Harlan's dissent in Plessy. And I gotta tell you, you stuck to your guns. You said Harlan was not correct in this context, right? Now, Harlan's dissent is celebrated, right? People say this like the greatest thing I've written. Frederick Douglass or Thurgood Marshall or these other people, they would extol Harlan, right? And you guys just said, no, he's wrong. And that's okay, because a lot of people today don't think Harlan was correct on this front. You did slip a little bit by saying the 14th Amendment, that discrimination on the basis of race, it doesn't quite say that. So just maybe check that up for your next round. I think the follow-up though from Hondo was about the 15th Amendment does mention race. So that was actually a good sort of, you help your teammate out. One thing you want to give some thought to is that if the Constitution says you cannot use race, and you're saying you can use race, those aren't the same thing. I think the response is, well, you can use race to benefit oppressed people, but not to harm them. But then the response you walk into is, what about other racial groups like the Asian Americans that perhaps are not being benefited? And I know you'll say, well, the numbers don't show that. I think that's a very good empirical debate, but I think you have to sort of just deal with the constitutional issue as well. But I thought both teams were very strong. You're all wise beyond your years, as we say. And I hope to see you in law school in 5 or 6 years, however many years you got. Oh no, 7 years for the freshmen. But you'll have very, very bright futures ahead of you. Do you have any questions for me or for Abby or for Daniel?
I guess I have a scheduling question first. You said this was the semifinal round. Is the very next round the championship round?
No. We got a couple. So the way we structure it is we have the semifinal round, and then we have what we call the round of 8, where the top 4 petitioner teams advance and the top 4 respondent teams advance. So it's possible that both of you might advance. It's entire. I haven't graded everyone yet, but you're not actually competing against each other. We advance the highest scoring 4 petitioner teams and the highest scoring 4 respondent teams. And that will be held on February 27th, in about 2 weeks. And then we have what we call the round of 4, which is, as the name suggests, the top 4 teams, which will be on March 27th and March 29th. Right, so you have some more time to think about it. And then the championship round will be in Washington, D.C. on April 24th. And we fly one of the teams out there. I think my friend from California would have traveled furthest, perhaps, but we'll see. Do you have any questions for us about law school, about the competition, anything in general?
I guess in terms of feedback for in this argument, I noticed that there were a lot of points that respondents made that I couldn't get to in my 5-minute rebuttal.
It's hard.
You have any advice on how to prioritize points?
I don't know, Abby and Dan, what do they tell you for both of these students are on our moot court team, so maybe they have some more pinpoint advice they can give you.
In order of importance, what you think would be the most persuasive and compelling. You're never going to be able to say everything, and that goes on the majority of the argument too. You're always going to leave feeling like, dang, I should have said all these things. So just try to prioritize based off what you think is the most compelling and persuasive.
I've been told, so for rebuttal in the law school world in moot court, we actually have a smaller time for rebuttal. It's normally about 2 minutes.
Hmm.
And so normally what you want to do is pick your 2 strongest points or your 1 strongest point and really tie it back to policy, because you want to avoid, and in the 5 minutes, Justice Blackman's going to ask you questions, but in the 2 minutes, you want to avoid questions. You want to get your point out there. And so sticking to policy normally prevents that and really like drives home what you're trying to say.
Any questions from Lauren or Han?
We have one question. On the question on what would have been the question about if 2 applicants were basically similar but odds of having different races, what would have been like the best response to that, if you can give it to us?
I wish I could. There's not a good one. I think what you sort of pivoted to talking about holistic, that you just have to keep repeating that one of many factors, factor upon factors. I think you have to sort of just keep repeating that line. It's not perfect. It doesn't get you all the way, but that's what you have to rely on. You didn't get the question with the checkbox. I think we asked it some of the students yesterday, but the question we've got asked for is why, if race is just one of many factors, why do you just focus on a single checkbox like the most important factor? Right. So that's almost a variant of your question. So there's something to think about. If go back and listen to the actual argument of the Supreme Court, which you may have already done. Did you already listen to it? Go back and listen to it again after you've done this round. You'll see the sorts of questions the lawyer for Harvard and UNC struggled on are those sorts of questions. There's really not a good answer. You sometimes, I don't know what they tell you in moot court, but sometimes you just have to take punches. If you ever watch Rocky, one of those movies, sometimes you're gonna get punched and you have to just take the punch and get back up and throw another punch. And you can't block every punch. So sometimes you gotta just take it and hope you can win on points.
Thank you, Mr. Blackman.
Oh, sure. I'm sorry to use a violent reference, but that's the best I can think of right now. All right, what else? All right, well, we will probably post the scores probably by tomorrow, I think. You'll probably hear back from us very soon. I have another 6 rounds to go today, so it's going to be all day. I'll be until 5 something. All right, have a wonderful day, everybody, and good luck. I'll turn the recording off. If the students can please sign off, I'll talk to the judges for a few moments.